This is probably a really great time to be having this conversation, considering the season of the year that we're in. It is January. We are in wintertime. And just last month, the Ontario government passed Bill 118. And what does that bill have to do with anything, Jess? Well, it deals specifically with basically how much time you have to file, reports of slips and falls that result in injury. Yeah. There was a very long window for people to file those complaints or reports previously, but that window has narrowed considerably with the passage of Bill 118. And it also narrows even more if you are alleging that you slipped and fell and hurt yourself on property belonging to a municipality. So what does this mean for you? What does it mean for companies? What can you do to protect yourself a little bit? Well, my next guest is going to be able to help us out with some answers on that. And that's Jasmine Daya, personal injury lawyer and managing partner of Jasmine Daya & Co. Thank you so much for coming back on the program, Jasmine. It's great to speak with you again.
It's great chatting with you. I'm happy to be here.
Yeah, the last time we spoke, I think it was around Halloween for COVID-safe activities and things like that. And now we're talking about, a topic that can have year-round implications, but certainly in the winter, it really does spring to mind, the idea of slips and falls and hurting ourselves.
Yeah, that's right. It was Halloween when we last chatted, and we're totally switching gears right now. Halloween has passed, the holidays have passed, and now we are into the depths of winter.
Absolutely. And this is, rather timely that Bill 118 was passed in December. That's the start of the wintry weather, usually for our region at least. And we're talking about slips and falls. And I have to tell you, I was very surprised at that large window that previously was in place for filing documentation about slips and falls. It was about 2 years, wasn't it?
That's correct. So in Ontario, we follow the Limitations Act, which states that you have 2 years to sue for personal injury. However, what this act has done, this Bill 118, which is an amendment to the Occupiers Liability Act, is it has narrowed the window. So yes, you still have 2 years to sue because we still follow the Limitations Act, but you must notify a party which you intend to sue arising from slip and fall injuries due to slippery conditions, so snow or ice, within 60 days. So you have to make them aware within 60 days that you intend on suing. And it's not enough to just make them aware. Your notice letter should contain details about the incident. So you need to indicate the date that you slipped and fell. You need to provide the time that you slipped and fell. And you need to provide the location. Other details that you'd normally want to include is what happened to you, what your injury was. And you have to advise an occupier or independent contractor or both. And then the Bill 118 takes it a step further and says, and you can't just send a letter or an email, which surprises me. I would think in today's day and world, especially with the rapid advancement of technology during the pandemic, that an email would be okay. But you must send this notice letter by registered mail or personal service. And what is personal service? It is what it sounds like. You must provide the letter in person to an individual.
Wow. Okay. So yeah, these are big changes now that have been put in place as a result of this. And I think that, a lot of people, if you are the person being sued, who they're alleging your conduct or lack thereof has caused their slip and fall, it's good to have all this information in a more timely manner. That way the incident is more than likely more fresh in your mind, and you have access to perhaps data that could later on be cleared out 2 years down the road. And if that was the case, if someone's filing 2 years from when it took place, it will be perhaps harder to defend yourself against that.
You're completely right again. I mean, that's one of the main arguments from contractors. They were saying, well, some of these lawyers, they wait till right before the 2-year mark to sue. And, it's not really the lawyers that are always waiting to sue. Trust me, I'm not waiting to sue because I want to advance the claim and move things forward so that I can move to a resolution sooner. The issue is more with the client. So my clients are injured. Normally when a client gets injured, their first inclination is not to sue. The majority of my clients aren't thinking about that. They're thinking about getting better from their injury, recovering. And unfortunately, through the recovery process, things happen. So they get the $45 ambulance bill from the hospital, and that is okay. Most of my clients think that they can handle that. It's a little irritating, but they can handle it. But there's other real costs that add up. Costs of medication, the cost of physiotherapy or chiro or whatever other rehabilitation they require. If they need time off work because of this injury, then they're losing income. And when all those costs start adding up, that's when they pick up the phone and start searching for legal advice and call a personal injury lawyer like myself. And usually, as I said, it's not the first few months, it's after several months. And that's one of the big issues with Bill 118. It's that a lot of my clients are going to contact me and I'm going to have to tell them, I'm so sorry, but there is nothing I can do to help you. Yes, you have 2 years to sue, but unfortunately, there was no notice provided within that 60-day time period.
Yeah, and it can be obviously devastating for someone if they find themselves in that predicament and, even maybe they didn't even realize that their injury was as serious as it turned out to be. Like there can be consequences to an incident, much further down the line, and they think, holy, I need some assistance here. There has to be some kind of accountability for what's taken place. And then they can be left in that position that you've described, which would be very upsetting for them.
That's right. I mean, the other reason that Bill 118 was enacted is because not only were the independent contractors or occupiers saying, we don't have these details anymore. So much time has passed. We can't properly defend the claim. But the other issue that had come up is that a lot of these snow removal companies, snow plow operators, their insurance companies had raised the rates, and it had become very difficult for a lot of these operators of companies to maintain insurance. And the reason for that is rates go up when there are claims. So if someone gets injured and they sue as a result of slipping and falling due to icy conditions that weren't cleared, then the insurer will kick in and defend the snow removal company, for example, and that will raise the rates of that snow removal company.
Yeah, so it's all very interconnected, and I can absolutely understand why people on both sides of this equation would be very interested in what these updates entail, and that's why it's good to have conversations like this where we can get everyone up to speed in terms of what they need to know should they find themselves in this situation, because things have changed quite drastically.
Yeah, exactly. And, I realize for a lot of people, this is not going to be that interesting maybe because, they're not in that predicament, thankfully. But I do urge all your listeners to pay a little bit of attention because someone may find themselves in that unfortunate situation. You want to be able to pass on that advice. Just protect yourself. Contact a personal injury lawyer or do the notice letter yourself and just make people aware so that if the need arises, you are entitled and able to seek compensation for an injury.
Certainly. And just quickly before we let you go there, Jasmine, one of the other stipulations of Bill 118 involves municipalities as well. So you have to serve your notice within 10 days if it's a municipality, right?
So that was actually already law, so that's separate from Bill 118, but you are correct. There is law that requires that if you slip and fall on a municipal sidewalk, for example, so when we say municipal, we're talking about the city. So you have 10 days to put them on notice. Now, this is very interesting because, yes, again, the Limitations Act says you have 2 years to sue. However, if you have not notified the municipality, and similar to the notice that I described earlier, you want to put the date, the time, the location, any other relevant details, what your injuries are, as much information as you can so that the municipality can do an investigation and they're not what we call prejudiced in any way. You need to do that within 10 days or you could be barred. Now, there is a case that went to court a few years ago because someone was so badly injured and in the hospital that they just could not put the city on notice within 10 days. And the court said that there was a reasonable explanation. You were in the hospital, and therefore the time extends. So, with Bill 118, we may see that in the courts. I'm not sure yet. There is a clause in Bill 118 that says that if the injury arising from the slip and fall incident causes an individual's death, then that 60-day notice period does not kick in. It does not take effect. And one other thing to note, because I didn't mention it earlier, but although Bill 118 has passed, there is no commencement date that's been set just yet. So we don't know when this will be enforced. With the pandemic, the courts have been so impacted and individuals have been so impacted that it may be as a result of the pandemic that we don't know the commencement date just yet. But it's coming because it's already law.
Well, Jasmine, thank you so much for your time this afternoon and running through this with us. Really a comprehensive look at this issue, and really grateful. And I'm sure that people are, much better armed with information now after listening to this conversation. Thank you so much for your time.
No, thank you for having me. It's been a total pleasure, as always.
Oh, thanks so much. We'll chat again soon, I'm sure.
Sounds good. Take care.
You too. Bye-bye.
Bye.
That's Jasmine Daya, personal injury lawyer and managing partner of Jasmine Daya & Co.